Ms. Hofmeyer, I seem to be without a pen this afternoon. They'll try and get one for me, but I think we can proceed.
Thank you, Chair.
Yes, thank you.
Chair, we next have the evidence of Mr. Manyi, who is also a returning witness.
Yes.
If I may request that he be sworn in.
Yes, good afternoon, Mr. Manyi. Thank you.
Good afternoon, Mr. Chair.
Thank you. Please swear in.
Please state your full names for the record.
Mzwanele Manyi.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you will give will be the truth, the whole truth and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may proceed, Ms. Hofmeyer.
Thank you, Chair. Chair, Mr. Manyi's affidavit before the Commission is in the file containing all of the affidavits for the evidence over the course of this week. I propose that his affidavit be entered as Exhibit NN2. And Mr. Manyi, you'll find it in the file in front of you under the second tab.
Mr. Mzwanele Manyi's affidavit contained in a legal arch file marked NN will be marked NN2.
Thank you, Chair.
What page is it?
It commences on page
I
1.
Found it.
Indeed. We'll be under tab 2 predominantly,
Yes.
and then we may move to one or other of the affidavits as we did with Mr. Maseko earlier.
Okay.
Mr. Manyi, you gave evidence at the Commission in November of last year, as I have it on the 14th, the 26th, and the 27th of November. Can you confirm that?
Chairperson, just before we proceed,
Yes.
just before we proceed, Chair,
Yes.
take this jacket. Is it okay if I take off my jacket, Chair?
If you're feeling too hot, that's
Yes,
okay.
Thank you. I just wanted to address the Chair on
Yes.
the issue of procedural fairness,
Yes.
which I don't think I'm receiving, Chair, and I want to state why.
Yes. Yes. Proceed.
On the 25th of October, I received correspondence from the Commission asking me to come and appear here to give oral evidence. Part of what is said in the memo is that I must come and give evidence and be asked questions on the withdrawal of your dismissal from the Department of Labor by Minister Oliphant, on your transfer from a position of DG of the Department of Labor to GCIS, and then and matters related incidental to that. I then responded to this, Chairperson. I say to the Secretariat that I'm confused as to what is this got to do with the state capture mandate, because from where I sit, this is a pure human resources matter, LRA matter, CCMA and stuff. What's that got to do with the state capture mandate? I go further, I say that in any event, people that were actors in this space were actually ministers. It's a minister that would have suspended me. It's a minister that would have purported to have dismissed me. It's a minister that would have reinstated me. It's a minister that would have transferred me. So where do I come in? If anybody has to give any clarity here, is people at executive authority level, not me. I was a subject of these decisions. So what am I coming to do here? And I said, I don't want to be coming here and waste the commission's time saying, I don't know, because these were decisions that were taken by the executive authorities over me. So what's that got to do with me? So I write back to them and I say, unless there was perhaps a contradiction in my earlier testimony, and I don't become general chair, I also become specific in the letter. I say, namely, the issue of my transfer. Now, part of the documents that I was given is the affidavit of former Minister Oliphant. Now, Minister Oliphant explains a lot of things, but at the end, she then explains that she therefore reinstated me, she therefore agreed to the transfer, she wanted me transferred, etc. So I then say to the commission, if anything, what I had said when I was here last is that I was transferred. So what Minister Oliphant has said is not a deviation from that. She's still saying I got transferred. So from where I sit, there is no contradiction. They pick up a contradiction because I said I was suspended, and she said I was dismissed. I said, so I'm saying, Chair, here, that whether, and we can go into that at the right time, but whether it's suspension or dismissal or whatever, bottom line is that that whole thing was rescinded, and bottom line is that I was then transferred, which was my original testimony. So what exactly am I doing here? Then I get subpoenaed to come here. So I'm coming here, I'm coerced to come here. So I come here under a subpoena. Now the subpoena comes, and the subpoena, notwithstanding that it also was at the wrong address, and I'm even worried about that, Chair, because if they have a wrong address, because just before you know, then they say they can't find you, then before you know there's a warrant of arrest and all of these things. Now, I don't know how the commission can not know my address. So they came up with some address in Cape Town, Claremont. Now, I've never even set foot in Claremont, but somehow I have an address there. But that's a side issue. The issue, Chair, is that then the summons come, and the summons raises three broad areas. It says you're subpoenaed to come and do 1, 2, 3. The first one, your tenure at the Department of Labor, your tenure at GCIS, and any other matter. Now, Chair, how do you prepare to the commission with such a broad canvas? I mean, Department of Labor on its own is a huge department. When somebody says your tenure at the Department of Labor, I immediately think of what could it be? I had compensation fund, I had UIF, I had the entire department of 7,500 people. So what exactly is the issue? And then GCIS as well is a huge department, had subsidiaries and all that. What is it when a subpoena says your tenure in those places? It's a open-ended, it's a blank check. And then over and above that blank check, then it says any other matter that is in the brief of the commission. So, Chair, I'm here saying I don't think that is fair. I am not adequately prepared to come here. Lunchtime today, Advocate Hoffman comes to me and says to me, can I give you a bundle from DPSA? I mean, this is like today lunchtime. Can I give you a bundle from DPSA? Then I say, okay, how thick is this thing? She says something like this. I say to her, how can you expect me between 2 o'clock and 2:30 to internalize whatever is being said in that bundle and all that? So, Chair, I'm here saying, I think, first of all, even the commission, I don't think they're ready for me, but I certainly am not ready. I think there should have been a bit more transparency, there should have been a bit more fairness, and I should have been given ample opportunity to prepare. I think the purpose of the commission is to assist the commission to get to the truth. It's not to be tricked. Right now, Chair, I must tell you, I feel like I'm here for an ambush, This is how I feel. Because memos will be popping up left, right, and center. Do you recognize this? Then I'll be looking and the cameras all over on me and looking stupid. I don't want to look stupid, Chairperson. I want to come here fully prepared and then I can deal with matters. But I don't think I should allow myself to go into an ambush like this. Because for me, I think it's an ambush. And in conclusion, Chair, I'm asking for adjournment up until the Commission can give me all the things I need to consider. And if there are areas that they want to traverse with me, they don't have to give me specific questions. Even if they give me areas to traverse, they must give me that so that at least I prepare. Just now, I mean, it's not fair, Chair, that I come here based on memory of what happened in 2012. And then I'm sitting here with advocates that are sitting with bundles, which they have studied these bundles. They know them backwards. And then I must sit here and rely on memory of 2012. This is grossly unfair, Chair.
Thank you, Mr. Manyi. And it's good that if you feel that you have not been treated fairly, that you have been able to articulate how you feel about the matter. I'm going to allow Ms. Hofmeyr to say something in response.
Thank you, Chair. Chair, there has been no ambush of Mr. Manyi today. And I make that submission off the back of the engagements that have taken place with Mr. Manyi preceding today. And I'd like to begin that, because there is a record of it, in NN2, which is the exhibit of Mr. Manyi's evidence, and it commences at page 117. Chair, it's not necessary to go to all of these documents, but I just want the record to reflect that they exist there. The interactions with Mr. Manyi commence in a letter dated the 16th of October of this year. I do understand that it was only received by Mr. Manyi, I think, on the 18th of October. But it was a letter that identified for Mr. Manyi that since his last evidence, there had been further investigations of the Commission. There had also been a further affidavit that had been received from Ms. Williams, in respect of which his comment and response was sought. And then the letter identified certain further areas of investigation, in respect of which Mr. Manyi's specific answer to a detailed set of questions was set out. All of that related to his tenure at the Department of Labour, disciplinary processes that were embarked upon in relation to him while he was there, the charges that he faced, the outcome of that process, whether indeed he was terminated as a consequence or during that process, whether there had been any appeal against the decision to terminate him. He was provided with a copy of the letter of termination that is signed by former Minister Mdladlana, dated the 29th of October 2010. And so it sets out all the areas of particular inquiry of the Commission as at the middle of October. That was then followed by a meeting with Mr. Manyi that took place on, I think it was Monday, the 21st of October. My learned friend will correct me if I'm wrong. Mr. Manyi was brought up from Cape Town for the purposes of that meeting. He sat with the investigators and the legal team of the Commission to go through his response to the questions that had been posed, in an effort for him then to be able to provide an affidavit to the Commission. That was followed with an affidavit from Mr. Manyi, for which we're indebted. It's quite a comprehensive affidavit, certainly in relation to its responses to Ms. Williams. In relation to the further areas of inquiry, it is much briefer. And pursuant to that, he was engaged to be asked to come and give evidence today. That's the letter I understand that he refers to. Subsequent to that, indeed, there are further records in the bundle. He raised concern as to why he was being asked to come and give oral evidence for what he termed as a pure human resources, labour relations, or CCMA matter. You'll find that correspondence in NN2 from page 128. In that correspondence, he himself says, and I quote, "What would have been of concern to both me and the Commission, in my humble view, is if the new information," this is the information he's referred to previously pursuant to the Commission's investigations, "somehow contradicts what I'd already stated under oath, namely that I was transferred." In response to that indication that he declined the invitation to attend, a further letter was sent to him from the Commission. That you will find again in the same exhibit NN2 at page 130. There it was explained to Mr. Manyi that the Commission had received an affidavit deposed to by Minister Oliphant, in which she says that after she was appointed as the Minister of Labour, Mr. Manyi had phoned her and indicated to her that he intended to appeal the decision to dismiss him, or to take the Department of Labour to court over his dismissal. And she further said that there was a further meeting between the two of them at which he had again indicated that he wanted to take the Department of Labour to court over Minister Mdladlana's decision to dismiss him. Now that, and then he was afforded a copy of that affidavit. Now that evidence must be read in context with the response that Mr. Manyi provided to the questions of the Commission. Because, Chair, you'll recall one of the pertinent questions Mr. Manyi was asked was, well, were you terminated? If you were, your position as DG, what steps did you take? Did you appeal? Did you not? And you'll recall I made reference to the letter of former Minister Baloyi dated the 29th of October 2010, which was provided to Mr. Manyi as the backdrop for those questions. Now, Mr. Manyi's response to all of that, in his response to the Commission, which again is at NN2 at page 38, says that he received the letter from Mr. Mdladlana relating to his termination from the Commission. He says the first time he was seeing it was on Friday, the 18th of October, 2019. He then indicates that he'd asked the Commission to obtain proof that the letter was sent to him, and he goes on to say, but I know there is no such proof, in essence, because Mr. Manyi's version is he never received that at all. It's in the context of that indication to the Commission that Minister Oliphant's affidavit then raises a serious matter for further investigation, because former Minister Oliphant's affidavit, as we understand it, is saying, but there were engagements between me and Mr. Manyi about an appeal against the decision to terminate him. She also indicates in her affidavit that she took steps in January of 2011 to withdraw that very termination. But what at this point Mr. Manyi has told the Commission is that he never received the letter terminating him. And so that was explained to Mr. Manyi in the correspondence that I referred to at page 130. And it was indicated to him that there certainly was a contradiction then between what Ms. Oliphant had said and what Mr. Manyi had said to the Commission. And it was off the back of that and the other matters that require investigation that the summons was issued and, I understand, successfully served on the Johannesburg residence of Mr. Manyi yesterday evening. Nonetheless, I understand Mr. Manyi received that correspondence, indicated that he would come up to be present today, and so travel arrangements were made for that purpose. Chair, it's against that backdrop of the facts that it will be our submission before you today that there has been no ambush of Mr. Manyi. Mr. Manyi also, I should record, requested a copy of the bundle of his affidavit that was provided to him in its paginated form, I think either Friday or Monday this week. Mr. Manyi can confirm that. What was also made clear to Mr. Manyi in that correspondence is that there were further documents that were being sought and obtained by the Commission. that those had not yet been completed, that efforts were afoot to do so as expeditiously as possible, but he was indicated that if there is any document in the course of the proceedings today that his attention is drawn to, that he hasn't seen recently, doesn't remember, wants time to consider, it would be the position of the legal team that he should be afforded that time, even with the possibility of a short adjournment if that was necessary. All of that was made clear to Mr. Manyi in correspondence. The final point on this, Chair, just to conclude, is that I mentioned this morning that there was still an affidavit from DPSA that was outstanding. We successfully did receive it in the course of the morning, and it was for that reason that I, as Mr. Manyi has correctly pointed out, approached him over the course of the lunch break, when it had been added to the files and paginated, to afford him an opportunity to consider those documents. It's against that backdrop, Chair, that it is our submission to you today that we continue with Mr. Manyi's evidence.
Mr. Manyi would like to reply.
Yes, Chair. A couple of things. Firstly, it's important that we are very clear about the contradiction between what I've said about my suspension versus dismissal. That seems to be what Advocate Hoffman is saying. And we can deal with that at the right time. But the issue for me, Chair, is that discussion, whichever way it goes, is still an HR matter, it's still an RA matter. I'm still trying to understand why is it in this commission that matter, because it's a human resources matter and all that. And in any event, the fullness of that thing is that whether it was suspension, whether it was dismissal, it was rescinded. So what is the materiality of discussing something that was actually rescinded? Whichever way it was rescinded, that thing. So what is it that we're dealing with here? We're going to open that LRA matter through backdoor, or what are we doing? And the issue also then, Chair, in terms of fairness that I'm dealing with here, I then asked for the bundle. And Advocate here, when she says the bundle was given, an impression will be created that I have all the information, which is not true. When I asked for the bundle, I wanted all the information that I need to consider to come here. All they gave me for the bundle is what I gave to them. It's my affidavit, which I know backwards. It's the annexures, which I gave to them. They just played those back to me. And then also just the correspondence going backwards and forwards. But the rest of the other things were not part of this bundle. For instance, they say any other matter. What is in the subpoena? It says any other matter. I don't know what is any other matter. Now, if in the absence, in the bundle, in the absence of anything relating to the Department of Labor, in the bundle, I'm not even sure whether the responses I gave earlier on were enough to stop the matter or not. So in the absence of them there, I think, okay, maybe then they've been dealt with, and so on. So this is why, Chair, I'm sitting here. There are three areas that the subpoena is reflecting on. The subpoena talks about my tenure. It's not even specific. Now, the subpoena is broad. This is my problem, Chair. The subpoena is broad, and it's a legal document. I've got to consider what the subpoena says. The subpoena wants to talk to me about my tenure at the Department of Labor. That is far broader than what Advocate is saying. The subpoena talks about my tenure at the GCIS. That is far broader than whatever she could have said now. Over and above that, it says any other matter. Now, Chair, that can't be fair. I can't come here and pretend to be a spokesperson of GCIS and speak in my tenure there. I don't even have the mandate of GCIS. I don't even have the mandate of the Department of Labor. How can I come here and then come and talk about my tenure when I was there? If there are specific questions that relate to me, it's not like, Chairperson, when I was there, I was a consultant that was just doing work, therefore come and explain what you did there. I was a full-time employee and I was executing government mandate. So if anybody wants to know what happened there, they must ask GCIS, they must ask Labour. But if there is something personally dealing with me, then I must be confronted up front and be asked questions. I mean, there are other questions that they had asked me earlier that she's referring to. I responded to those questions. If maybe it's a follow-up to those questions, why am I not getting told that your answer here was inadequate or whatever? You know, so I come here, I'm drawing a blank as to which way things are going to come and all of that. I don't think that is fair, Chair. I think the summons or the subpoena must have full particulars so that a person knows what a person is in for. And finally, Chair, I say this because it is my opinion that people that sit on this chair are not treated the same. There are those whose evidence is properly led and they're even reminded about things that they need to say in their own affidavits. There are people that are treated nicely like that here. There are some of us who come here to be crucified and all that, and we are ready to deal with it. But the only thing we're asking for is fairness. We must be given proper documentation so that the person can prepare and make a proper submission.
Thank you, Mr. Manyi. Certainly, from my side, I would like to try and make sure that everybody is treated fairly. All witnesses are treated fairly. Even if it's an implicated person, when they give evidence, they must be treated fairly. But I accept that there may be cases where I think somebody is being treated fairly and they have a different view, and that's normal. I accept that there may be other people who may take a different view about whether we are being fair or not, and we accept that they are entitled to take a view on how we deal with things. But we will continue to do the best that we can. We don't guarantee that we will satisfy everybody, but certainly from my point as chairperson, I want us to continue, all of us, including the legal team, to continue to do the best we can to try and make sure that there are no complaints of unfairness. As I have said before, there will be times when somebody thinks they are treated unfairly, and I take a different view and I make a ruling. And I make a ruling in accordance with my own judgment of what's fair and what's not fair. But we will always try and do the best we can, certainly from my side, to make sure that there are no concerns of unfairness, and where there are concerns, to try and see how they can be met, to try and make sure that everybody feels that they are treated fairly. But I think, Ms. Hofmeyer, the point that you didn't address in your response is the one about the scope of what Mr. Manyi is sought to be asked about today. So I think you must address that.
Certainly, Chair. I'd like to pick that up in relation to a point Mr. Manyi made in his reply a moment ago, which is that there wasn't clarity for him as to where the contradiction between Ms. Oliphant's affidavit and his responses to the Commission lay. And I'd like for that purpose, because it is the backdrop to the engagements and the subsequent summons, just to draw that to your and Mr. Manyi's attention. That again is in Exhibit NN2 at page 130. There, the Commission, through the Secretariat, made it clear to Mr. Manyi in response to his concern that this was a mere labour matter and didn't merit his giving oral evidence, but his acceptance that if there was a contradiction between his versions and those of others, that would warrant the attention of the Commission. What happens at page 130 in the correspondence with Mr. Manyi is those aspects of Ms. Oliphant's affidavit are highlighted, and then the following is said. Ms. Oliphant's, I see it says email, but it should say affidavit, directly contradicts your response to the Commission that you had no knowledge of Minister Mdladlana's decision to terminate your appointment as Director General of the Department of Labour. So it is my submission that there could be no doubt in Mr. Manyi's mind what precisely had been identified as the contradiction. That occurred, that correspondence was sent to Mr. Manyi last Friday, and it was, in addition to it, was a copy of the summons that was being served on him. So he received a copy last Friday, and let me just give the actual language of the summons to you, Chair, if I may. He's asked to attend today for the purposes of evidence about and being questioned about the following matters being investigated. Matters relating to the period of Mr. Manyi's tenure as Director General in the Department of Labour and in the Department of Communication and Information Systems, and any other matters arising which are within the Commission's mandate to investigate allegations of state capture, corruption and fraud in the public sector. Chair, it is not the case that it's any matter arising. It's a matter that falls squarely within the mandate of the Commission, and it's my submission that the summons makes it clear that the matters which he will be questioned on relate to his period as DG of Labour, and Chair, what will become clear in the course of the evidence is that it will span that period because it will start with his appointment, it will move to his suspension, it will move to the matters that he's already been alerted to the Commission wants to investigate further, which is his suspension, the process of the disciplinary committee, what was its conclusion, what steps he took after, and then it is his arrival at GCIS and related, and the period there. Chair, that has been clearly identified to Mr. Manyi because he was given the affidavit of Ms. Williams. He was asked to comment on it. Ms. Williams' affidavit traverses the period of time that he held the position of DG of the Department of Communications and Information Services. So it's to span the period during which the questions will relate to, and it is my submission comes off the back of the repeated engagements and clarity that was given to Mr. Manyi as to the particular focus. The last point I wish to make in this regard is Mr. Manyi was aware of the scope of the summons as of Friday last week. There has been no indication from him since then that there's any lack of clarity on his part as to what would be traversed today with him in evidence. It is also the case, it is our submission, that it is not appropriate for Mr. Manyi at this stage of the proceedings to be objecting to giving evidence at all. Mr. Manyi is here under summons today to give evidence. If there is any question that is put to him at a point in the course of these proceedings in respect of which he has an objection, because it lies outside the scope of the summons or because he needs more time to consider, we could deal with it as the evidence unfolds in the course of the afternoon. So those are our submissions, both on the scope of the summons, what preceded it, and what the approach should be going forward in our submission.
Just deal with the question which he has articulated 2 times, namely, this is an HR LR CMA matter. What is it? What does it have to do with the Commission, with the terms of reference of the Commission? I think just deal with that as well.
Of course. Chair, it is our submission that this is not an HR or merely an HR, labour relations or CCMA matter, and I make that submission for 2 reasons. The first is that any evidence that is given to this Commission in the course of its proceedings that may be false is of grave concern to this Commission. And Mr. Mani testified in November of last year about his tenure at the Department of Labour, about the circumstances in which he was disciplined there, and about his move from there to GCIS. It is the intention today, in the course of the questions, to probe that evidence with Mr. Mani, because if that evidence is false, that should immediately be brought to the attention of this Commission. And those matters relate to the subject matter of human resources CCMA proceedings. But if what Mr. Mani said about those proceedings in his last evidence before this Commission are not correct, it is my submission that it is our duty, first as the legal team of this Commission, to place that before you, and furthermore to probe it. We are required under the rules to ask any questions that will assist the Commission in establishing the truth about the matters before it. The second significance, Chair, is the following. In the greater mandate of the Commission, precisely what happened prior to Mr. Mani being appointed as the DG, transferred to the position of DG at GCIS, is materially important. I've traversed it in the evidence this morning of Mr. Maseko. It happened in the space of a week. A series of events took place between the 25th of January 2011 and the 2nd of February 2011. It involved, amongst other things, removing Mr. Maseko from his position at GCIS, where there had been no prior indication of dissatisfaction with his position. It involved, on the Monday of the very same week that Mr. Mani was transferred to GCIS, the withdrawal of the termination of Mr. Mani's employment in the public sector. Precisely how those events unfolded, against the backdrop of Mr. Maseko's evidence that they were a consequence of him being unwilling to engage in the instruction that Mr. Gupta had given him to direct advertising spend to TNA, we submit is squarely within the state capture mandate of this Commission, merits further probing, and it is for that reason that we submit this is not a mere HR CCMA matter. It's about what decisions were taken and by whom over the period of a week to ensure that Mr. Maseko left GCIS and Mr. Mani took his place. Thank you, Chair.
Mr. Mani, you haven't had a chance to deal with the reasons being given by Ms. Hofmeyr as to why this matter is relevant to the business of the Commission. So I think I should let you deal with that.
Yeah, thank you, Chair. Firstly, I think I must deal with how Ms. Hoffman is dishonestly interpreting what I had written on the memo written to the Commission on page 128 on the 31st of October. It's point 4 on that memo, where I say, what would have been of concern to both me and the Commission, in my humble view, is if the new information somehow contradicts what I had already stated under oath. And then I say, namely, so I don't leave it broad. I specifically say, what is it that I'm dealing with? Stated under oath, namely, that I was transferred, full stop. Then I say, if anything, your own investigation that has brought up the former Minister Oliphant's name actually confirmed that Minister Chabane departed from a legitimate platform to effect my transfer. So this is the point, Chair. Now she takes the fact that I spoke about the contradictions and then just uses it as she pleases. It's not right. And that was, I never, she takes that to her own expediency. Whereas I was quite specific that the issue for me about the alignment between what I'm saying and what Ms. Oliphant is saying is purely on the transfer. It was on the narrow issue of the transfer. I said I was transferred. Up to as we speak right now, there is no evidence to suggest otherwise. I was transferred. Even Mrs. Oliphant in her own affidavit, she says I was transferred. And so on. She explains how that transfer happens and all that. So that's the contradiction I was talking about, that there is no contradiction. In fact, they have found evidence. If maybe, I mean, at this point, all we had was a letter from Minister Chabane that was talking about a transfer, which in fact, one of the questions when I was asked, why do I say I'm transferred? And I took actual exception to this. I said to the Secretariat here that this letter was given to you. The word transfer appears 4 times in this letter, but you're still asking me why am I saying I was transferred, and yet we've got a letter that says I was transferred, and the word transfer appears 4 times. What do you want me to say? And then now they bring up new evidence of Ms. Oliphant, and Ms. Oliphant again says reinstated and what have you, and then she then says in her letter, she says she decided that the option she was given 2 options by Minister Baloyi, apparently. She says in the affidavit. She was given either I be reinstated into the department or I get transferred. She makes the election herself. She says, I decided to transfer. In fact, she mentions 2 reasons for her decisions. She says, A, because she understood me to have been dismissed, so she didn't want me in the department. That's what she says. She says, B, she also wanted peace and stability because also she had received a memo from NUMSA, from NEHAU, that was calling for my reinstatement. So I think she just foresaw some power dynamic of sorts, and she decided that it's best that I get transferred. So this is why, for me, I think the importation of corruption and capture by the advocate is totally misplaced. This was a decision by Minister Oliphant. She had a choice of keeping me in the department or not keeping me. She made the election of transferring me and all that. So, and again, Chair, I then say as well, people that were making all these decisions, it's not even me, it's people outside me that were making these decisions. Why am I the person that is responding to decisions and all kinds of things that were done that impacted on me? And it was not my, I was not exercising any power. I was a pawn in the process. Why are you calling a pawn? Why don't you go to the people that were playing the chess and ask them why did they move this pawn from here to here? And I insist, Chair, that I mean, even if you look at the genesis of this matter, the person that started this matter is Minister Mdladlan by suspending me. So this is where the genesis of this matter comes and ends up where it has ended up. And to then, all of a sudden, try to find state capture on this matter, then it means then you must first call Mr. Mdladlan to explain what was his original motive for suspending me and all that. And I can assure you, it's got nothing to do with, well, if there's anything to do with the state capture, I'd like to see the evidence of this. But as far as I'm concerned, this matter is a pure HR matter. In fact, you can even look at the recommendations. The recommendation of Minister Mdladlan in the letter that Ms. Hoffman erroneously calls a termination letter. It's not even a termination letter. That letter must be read for the record, Chair. That letter, the probation letter of sorts, we can deal with that, but it's actually factually incorrect to call that letter a termination letter. So it's another discussion. But at the end, he recommends that if I'm not happy with his decision, I must go to PCSBC, the bargaining council. Minister Oliphant, after our discussion, she had recommended that I go to DPSA and all that. Clearly, these are all labor-related issues and all that. So as to why Advocate Hoffman is seeing state capture in a pure labor relation, sorry, Ms. Hofmeyer, sees state capture in a pure Labor Relations Act, CMA, human resource matter, is just beyond me.
Okay. 2 matters, Mr. Manyi. I think that the I'm not looking at the summons here, I've not looked at it, but based on what Ms. Hofmeyer has read to me, reading the summons, I think that you may well have, it may well be that the summons could have been formulated in a more precise way than it was. Because it might look quite wide, whereas I think listening to what Ms. Hofmeyer said, it might be specific matters during your tenure that they are looking at. So that's the one point. The second point is that to the extent that you may be asked questions that relate to matters where you need more time to recollect or to look at documents to refresh your memory, that might be something that might be looked at as part of trying to make sure that there is fairness. But it may be that there may be questions in regard to which you would not need more time, you would be in a position to deal with. So that's what I want to say about that aspect. With regard to the issue of what your transfer and dismissal or purported dismissal may have to do with the terms of reference of the Commission, I will share with you what I'm interested in finding out. We had evidence last year, which was confirmed this morning by Mr. Masego, that he was the CEO of GCIS, that he had a meeting with Mr. Ajay Gupta, and that on his version, Mr. Ajay Gupta made certain demands on him for the media budget of government to be effectively transferred to their entity or entities, and that he refused to cooperate, and that on a certain Saturday in October 2010, while he and his wife were driving to Northwest where he was going to participate in a golf tournament, he got calls from people from within the Gupta entities, one of which was Mr. Ajay Gupta, and they had a conversation which, according to Mr. Masego, was not pleasant, or at least did not end pleasantly. He said he even used an expletive in the course of that. But one of the things that he said is that Mr. Gupta, if I recall correctly, and I hope I do recall correctly this time, one of the things that Mr. Masego says Mr. Gupta said to him was something to the effect that because Mr. Masego was not cooperating, or was not prepared to cooperate, he would report him to his seniors, and he would be, I think he used the term, sorted out, or something to that effect. That was, if I recall correctly, towards the end of October. And then it's November, December, according to Mr. Masego, end of January. He says Mr. Minister Shabane called him and said the former president had instructed Minister Shabane to remove him from GCIS. And Minister Shabane said to Mr. Masego, well, I won't throw you into the streets because I know you are a good civil servant. I'll try and see where you can be transferred or something to that effect. So, last year and this morning, I asked Mr. Masego how his relationship was with Minister Chabane. And he says, in effect, very well. They worked very well together, and they had no issues. The former president came and gave evidence, and if I recall correctly, his evidence was that he didn't instruct Minister Chabane to remove Mr. Masego from GCIS, and he said something to the effect that the transfer of Mr. Masego must have happened because maybe his minister didn't want to continue working with him. I'm paraphrasing, because he said it did happen that sometimes ministers are not happy with their DGs and then they would approach him. Actually, I think at some stage, if I'm not mistaken, the former president said something along the lines that sometimes the ministers used his name, I can't remember, used his name to get DGs transferred. So one of the things I'm interested in is whether Mr. Masego's transfer was connected with what Mr. Ajay Gupta said to him, according to Mr. Masego. Now we have a situation where Mr. Masego effectively says, I was a very good employee of GCIS, and this morning we saw that the last performance assessment that he was given a score of 114%. He says, I was performing very well. I never got anything below 100%. And I never committed any misconduct. I was never alleged to have committed any misconduct. But I was removed. I didn't initiate my transfer. So now you replaced him. You were transferred from the Department of Labor to GCIS. So it becomes necessary to understand your own transfer. Now, the investigation that has been done by the Commission has revealed a letter written by Minister Oliphant, who was the Minister of Labor at the time of this transfer, where she says she was withdrawing your dismissal and then putting you on special leave. If I recall correctly, the letter is dated either the 1st or the 2nd of Feb 2011. So 1 day or 2 days before.
31 January.
Or 31 January, okay. So it happens around this time of this transfer, this issue of the transfer of Mr. Masego. And I may be mistaken, in her affidavit, understood her to say she withdrew your dismissal because that's what Minister Baloyi said. So one needs to understand how did it come about. If you had been dismissed, why was the dismissal withdrawn? Was that to facilitate your transfer? What was happening? And you are right in saying that maybe a lot of those things need to be explained by other people and not you. On that you may be right. But certainly Minister Baloyi will be coming. He has put up an affidavit. He will be coming. Former Minister Mdladlana has been interviewed by the lawyers from the Commission. He may or may not be called, but he certainly has been interviewed. Ms. Oliphant is coming tomorrow. So those who will be called will be asked. But from my side, it's important that which one can hear from you as to what do you know about this. I mean, there's the issue of whether you knew about the dismissal. That's one thing, because Ms. Oliphant says something about a meeting that she had with you. So the whole idea is to try and understand what were the reasons for Mr. Masego's transfer from GCIS to DPSA, and is there anything in regard to your own transfer and withdrawal of dismissal that could throw light on the transfer of Mr. Masego? So that's what in regard to your transfer, that's what I'm very interested in. So having said that, if I can, I don't want to make a ruling. I would like to see how we can accommodate your concerns and still be able to move forward, partly because the Commission doesn't have a lot of time left before it finishes its work, partly because the Commission may have paid for you to come here, and we would like to make use of that. But we must balance that against trying to be fair to you. So what I had in mind, and I would like to hear what you have to say, what I have in mind is whether you don't think it would be fine to say, let's get going, and those questions with which you don't have a problem because you can deal with them, you don't need more time, you deal with them. If we come to those where you might need more time because you need to refresh your memory on documents or whatever, let's deal with them maybe as and when they occur, or towards or later, but we try and cover what we can. What do you think about that?
Yeah, thank you, Chair. We are sitting here, Chair, with benefit of hindsight. And if I understand the essence of your issue is whether the corrupt intentions were fulfilled. I'm putting words in your mouth, Chair, if you just bear with me. If the corrupt intentions were fulfilled by me taking over after Mr. Masego. Now, there is a very clear history or trajectory of what happened when I took over after Mr. Masego. For instance, just by way of example, Mr. Masego mentions, I think, a figure of 600 million that he was meant to have enabled, as it were. We have information here that was given by National Treasury to say that from January, I think from 2011 to 2018, money that was paid to TNA stable amounts to something like 250 million, around that number. This is up to 2018, it's not even the 600 million. But that was not just from GCIS. This was from national, provincial, local, total money paid. Now, the money that, for instance, GCIS paid in my tenure, first year in 2011 was something like 8-point-something million. 2012, 7-point-something million. Those are the kinds of numbers. Now, which I think to any reasonable person is a far cry from 600 million. And of that 8 million or 7 million of this next year, not one of those transactions there's an issue of irregularity on. They were all done above board and all of that, as it were. And all the decisions were done without my personal intervention. There's no record of anybody in GCIS saying, I coerced them to do 1, 2, 3, which was the reason I even had to do that SMS mistake, because the bullying that Ms. Williams was talking about happened in 2013 or somewhere when I was long gone. And I see even media, I was seeing a chair even yesterday in the Citizen when they were talking about me coming here. Part of the narrative is that I was involved in bullying the department to go into breakfast, something I never did. This is why for me it was so pressing that I deal with that matter, that the issue of breakfast has got nothing to do with me and all of that. So, Chair, I'm sitting here, I'm saying, why am I actually here? Because if anybody in my tenure has got a specific irregularity that you can point at, we can deal with that if there's any. And I can tell you now, Chair, there's no irregularity during my tenure. The other things about how I came here, Minister Baloyi is coming tomorrow or any other day. Minister Oliphant, the archives, those are the people, those are the players. I was a pawn.
But we also need to know what you knew. So see, that's part of, they might say whatever, and maybe some of the things they say you might not agree with. You know, I don't know whether when, for example, Ms. Oliphant says in her affidavit, she had a meeting with you where, as I recall her evidence in the affidavit, you said you were going to appeal against the dismissal. I don't know whether you agree with that version or not. So that's part of what, for me, is important. But I think that to strike a balance, it might be preferable to say, let's proceed. Those questions which you are able to answer without any difficulty, do so. Those where you need more time, articulate your request, and then let's take it from there. Would that be all right?
Okay, Chair.
Okay, thank you very much. Yes, Ms. Hofmeyer.
Thank you, Chair. Mr. Manyi, I was beginning with your evidence in November of last year. That occurred on the 14th, the 26th, and the 27th of November. Mr. Manyi, I understand that you raised an issue with the Secretariat about an incorrect recordal in the transcript of the 26th of November when you took the oath. The question that was put to Mr. Manyi was, do you object to taking the oath? He said no, but the transcript records yes. Mr. Manyi, did you raise that concern with the Secretariat?
Yes, Chair, I raised the concern, and I've already been given feedback that has been sorted out. It's been straightened out, so that's why I'm not raising it here.
Okay, thank you.
Super. Right. If we can then go to the questions that you received from the Commission in the letter dated the 16th of October 2019, that you will find in NN2 commencing at page 117. Chair, I don't suggest we have to go to it immediately, but there were, I would suggest, Mr. Manyi, two sections to that request. The one was to ask you for responses to Ms. Williams's evidence, and the other was to ask you about the matters we've been focusing on recently, and that occur under a heading, the disciplinary process when you were at the Department of Labour. Do you recall receiving that request? The letter concludes...
Hang on. Mr. Manyi hasn't been here for a long time. He has forgotten that if he nods, that's not captured in the record.
Yeah, yes, Chair.
Yes.
Thank you,
the answer
Chair.
is yes.
Yes, Chair.
Yeah.
That letter concluded requesting you to provide...
I think you can keep your mic on, Mr. Manyi. I'll keep mine off unless I have to say something.
And I'll take care of turning mine off at that point, Mr. Manyi, so you don't need to worry about your microphone. That letter concluded asking you to provide an affidavit addressing the issues in the letter. What then came were two documents, Mr. Manyi. The first was an affidavit, and that you will find in NN2 from page 1.
Yeah.
And that concludes at page 24, as I have it.
Yeah.
And that was deposed to as an affidavit. Is that correct?
Yeah, that is correct, as an affidavit.
It is then followed at page 25 with what appears to be a letter not deposed to before a Commissioner of Oaths. Is my understanding correct?
That is correct, yeah.
Your answers to the questions about the disciplinary process appear only in the letter and not in the affidavit. So I'd like to give you an opportunity now to go to page 38 of NN2.
Yeah.
On that page, from paragraph 7, you are responding to the questions about your disciplinary process, and you set out your answers to the questions there. Is that correct?
Yes.
Given that this wasn't deposed to under oath, can you now confirm under oath that the answers you give here in this section of the letter are true and correct?
Yeah, that's correct. Yeah.
Thank you. I'd then like to go to your transcript. You indicate that some of the evidence about which you will ask questions occurred on the 26th of November. I think they actually began on the 14th of November, and so I'd like to take you to that transcript. Chair, we've prepared a bundle of the transcripts of Mr. Manyi's testimony because it is important that we go to the specific pages of those transcripts. So if I could beg leave to hand that up to you, and Mr. Manyi, you should have a copy available on your right.
Yes, maybe somebody
Which one of these
could
files?
approach him to indicate which one it is, unless it's clear from what's written which one it is.
It is written on the side, Exhibit NN, transcripts bundle. Do you see that, Mr. Manyi?
Yeah.
Sorry, just for the record.
Yes, I've got it.
Yes, thank you. And if I may beg leave to hand up a copy for the chair.
Yes. I've got it.
Thank you, Chair. The file comprises the 3 relevant transcripts of the 14th of November, the 26th of November, and the 27th of November. And I'd like to start, if I may, in the relevant part of the transcript of the 14th of November. Mr. Manyi, you'll pick that up at page 89 of the 14th of November transcript. Unlike in other
That's
cases...
under tag?
Apologies?
That's under tag what?
Under tag 1, apologies, Chair.
Oh,
That's the
okay.
first tag,
Yes.
which contains the 14 November transcript. And unusually, you now need to look at the bottom of the page for the relevant page of the transcript. Usually, we look in the top right-hand corner for the pagination, but now we are in the bottom of the page because that's how the transcripts are produced for the Commission.
What's the page number?
89, 89.
Thank you.
I'd like to pick it up towards the bottom of the page because prior to this in your evidence, you've been talking about the approach that Minister Shabani made to you. And you'll see the chairperson is recorded in about the 6th line from the bottom as having asked you, in other words, his approach, that's a reference to Minister Shabani's approach to you, was it in response to any request made by you or wish to be moved from the position of DG of Department of Labour? And then can you give us your response as it's reflected there?
Well, I said no.
Continue to read it till the end of the page, please.
I said, no, Chairperson, no, it was not. I had not requested to be moved to that position, but there was a situation that I think government was dealing with because at the time, at the Department of Labour, we had some kind of a fallout with the minister at the time.
Thank you. And then if you go over the page, please indicate what you continued to say.
I said, in fact, I was on precautionary, what is it, on special leave. That's what I say here.
And then the chairperson interjected and questioned, were you looking for the word suspension? And then what did you say in response?
I said, no special leave. It started as precautionary. It started as precautionary leave, then it graded into a special leave and all of that.
Right, and then further down that page, you were asked about the approach again, and the chairperson asked for clarification. All right, and then this approach from you saw as an approach to try and deal with that situation, because previously you'd spoken about the fallout between yourself and the minister, and your response there from yes, what did you say in evidence previously?
Is that, I don't know which...
Apologies, middle of the way down, after the chairperson's question, okay, all right, and then this approach from him, you saw as an approach to try and deal with that situation, and what was your evidence?
Yeah, I said yes. I thought it was a resolution because I had been at home for a couple of months, a few months actually, and so when this came, I said, oh, well, because even... I think there's some grammatical error in this transcription here, Chair, so I read something which I even feel is wrong as I'm reading it.
Yes, no, that's fine.
I said, well, because even for that, without going into that detail, I never got really charged into a disciplinary process and whatever. And so when it was something that was about to happen or going to happen, months rolled by.
Thank you.
I was sitting and...
you can continue.
I was sitting and preparations were being made to do all kinds of charges. But bottom line is that I do not sit with a guilty verdict or having said and being dealt with by the DC. So while that process was busy rolling and so on, I think sanity prevailed from where I sit, and then I had to move on.
Thank you. Mr. Manyi, I'd like your comment on what I understand the gist of that evidence to be. I understand your evidence to be there had been a fallout between you and the Minister of Labour, Minister Mdladlane. Is that correct?
Yes, correct.
That you had never been charged in relation to a disciplinary process. Is that correct?
I think elsewhere, that's not correct. I think elsewhere, I do mention, I don't know whether it's here or where, that there was a process, there was a sitting chair where there was all the lawyers and the chair of the DC. And I think about half an hour or something into that process, the chairperson got a call. And from then onwards, the proceedings stopped and the meeting was adjourned. This is just my recollection. And that was it. That was the end of the process and all of that. And then I went back sitting home again. This is my recollection.
Mr. Manyi, that evidence does not appear in any of these three transcripts. There was no reference to 30 minutes into a disciplinary hearing. You may be recalling what you have said subsequent to the engagements with the Commission. But what I'm interested in is what you said here. Apologies, Chair.
Okay, no, I think you've got that. I thought I wanted to explain, Mr. Manyi, that in regard to questions that Ms. Hofmeyer may ask and refer you to the transcript, you may have a situation where what she's wanting you to do is to confirm what answer you gave at the time you gave evidence, which might be different from what you might say now. For example, if when you gave evidence, you might have said, this is the answer, because that was your recollection at the time. Okay. But since then, maybe you have seen some documents that have indicated to you that actually your recollection was incorrect. So if you were to be asked the same question now, you would say, no, that's not the answer I would give, but that's because I've had time to recollect or I've seen some documents. So I just want to make sure that as she asks questions, remember that sometimes she might be asking you to just confirm what you said then, which might or might not be necessarily the answer you would give now, if in the meantime something has refreshed your memory.
Okay.
Yeah.
Accept.
Okay.
Thank you, Chair. So let me get clear. When you said previously, I never got really charged, are you saying that was not correct?
So I think following my clarification, Mr. Manyi, I think when she puts the question like that, it might be vague to you. Because she could be saying, are you saying that's not what you said here? Or she might be saying, are you saying now you were not charged? Now, I don't want to paraphrase the question for her. Maybe with that in mind, Ms. Hofmeyer, you can just either put it again or clarify whether you want him to say what he said previously here, or whether you want him to say what he may be saying now, if it might be different.
Thank you, Chair. I'm indebted. Mr. Manyi, in your evidence on the 14th of November 2018, did you testify that you had not been charged?
Yeah, Chairperson, yes.
And do you maintain that today, as you sit here giving evidence, that you were not charged?
Can I just say this, Chair, and then so that we don't speak semantics?
Yes.
There was a bundle with the state, there is a state attorney bundle where the list of allegation stroke charges are listed, as it were. There's a whole pack of that. Then there was a process that we needed to go through to deal with that, where I defend myself. I had already made submissions to all the allegations. Now, so that process happened. Part of the questions here to say what were the details of your charges, I responded to say state attorney has got all the files. So I've got even in my a mental picture of a very thick file that has got a list of allegations stroke charges. And I know that we've responded to them. Now we needed to sit onto a DC to deal with those things orally, as it were. Now, it's a technical question whether you were charged or not. So if
I understand your
yes, this is why I have a dilemma.
No, I understand.
Yeah.
Maybe let's put it this way, Ms. Hofmeyer. Did you, in terms of what you said before the commission previously, are you able to say whether your evidence reflected that you had received allegations of misconduct from the department, or do you not recall whether your evidence was to that effect?
I don't think that question arose.
Yes, okay.
Yes, but the fact of the matter, I
Yes.
did.
The fact of the matter is that you did receive allegations.
Yes.
And you say there was a meeting at which your understanding was that those allegations would be dealt with and you were supposed to defend yourself.
Yes.
But it was not taken to finality.
Yes, Chair.
Okay, Ms. Hofmeyer?
Why did you say in your evidence on the 14th of November then that you did not get charged?
It's because I thought, okay, maybe it's a technicality, Chair. My meaning for that is that if we go through a DC, then allegations get tabled or whatever. Then we have that discussion in the DC, and some ruling is made one by one on some of the allegations, stroke charges that are made. The issue I was trying to talk to is that didn't happen.
Are you saying your understanding of being charged would be that at a session such as the one you are talking about, somebody would then say to you, Mr. Manyi, you are charged with A, B, C, D. Is that what you're saying? That's what you would call being charged?
Correct, Chair. Because, or put differently, if there was, that's what I'm saying, Chair, yes.
Okay, thank you. Ms. Hoffman.
So just to clarify for my purposes, Mr. Manyi, you don't understand it to be the case that if you receive a list of charges from your former employer, identifying those aspects which you must go to a disciplinary to answer, that isn't yet being charged. Is that your evidence?
I suppose, Chair, that could be charges. Yeah, but I thought charges were a step above allegations. I have a list of allegations that I had to respond to. So I thought there would come a time when allegations get taken to the next level, that you've responded to this. With your response, we have not successfully addressed allegations. Therefore, you are charged with whatever. So that is, for me, the process in my mind about a person being given a whole list of allegations that still must be processed to be charges because we failed to respond to them. So I was given a list of those allegations.
And if the document were given referred to them as charges, would you still only regard them as allegations?
Correct, Chair. I would still regard them as allegations because a charge is something that is a bit more objective, that would say in terms of this, let's say whatever, and it's proven to be like that, then that charge sticks, as it were. But any allegation cannot be elevated into a charge, even if you call it a charge. It becomes a charge once it has been fortified. But if it has not been properly fortified, it's an allegation, even if you call it a charge.
Mr. Manyi, just to go back to your evidence of the 14th of November and bearing in mind the Chair's direction as to be clear as to whether I'm asking you about what you said then or what you say now, do you accept that your evidence before the Commission on the 14th of November was that you remained on leave from the period you were put on precautionary suspension through to special leave until the time that you were transferred to GCIS?
Yes, correct. Correct, Chair.
And the other aspect of your evidence was that there was no guilty verdict from the disciplinary process. Is that correct?
Yes, correct, Chair. I don't even have the report of the session, even as we speak.
Okay.
So let's just talk about that disciplinary process, if we may, for a moment. As you sit here today, do you maintain that from the period you were placed on suspension till the time that you were transferred to GCIS, you were always in the employ of the Department of Labour?
That is my understanding, Chair. It was called precautionary suspension. I think there are two different things. There's a suspension, which is a punitive suspension, then there's precautionary suspension. I was on precautionary suspension, whereby I was getting paid in that process.
Were you paid throughout the process?
That's my understanding, yes.
Were you paid in December of 2010 and in January of 2011?
I was paid in December 2010, yes. 2011 payment, January came late. It came in February.
So no issues with your receipt of a salary alerted you to the fact that you weren't still in the employ of the Department of Labour?
In fact, the December one was the clearest sign because I think the department, Chair, were getting paid there around the 15th. Unless if the 15th is maybe in the weekend, then you get paid on the 13th. So so around mid-month in December 2010, which in fact is another issue for me, that if I'm told that from 1st of December, basically we're out of the system, so how come in my bank statement in December, I've got, in the Department of Labor, Chair, the payroll is called, on the bank statement, it appears as manekrach. So I've got manekrach transactions that have come through for me in December. So I had a happy December in 2010. So I didn't understand myself to be dismissed.
My Afrikaans is not very good, but I wonder whether manekrach is anything like manpower.
Yeah, must be, Chair. Must be, Chair. But yes, must be manpower.
Okay.
But that's how the Department of Labor.
Okay.
So as at December 2010, you had no knowledge that you had been dismissed from the Department of Labor?
Like I explained, Chair. By the way, when I was preparing for this, I actually went to Nedbank and said, can you give me a statement for December? Just want to see if I got paid. And if the Chair wants to see, I can show you the statement here and now that I got paid in December. So there's no evidence that I was not in the department. Manekrach, the same payroll system that has been paying me throughout, paid me in December.
I think that would be important if you've got
can you show you?
that,
Right here.
Thank you, Mr. Mani. My question was, in fact, whether in December 2010 you had no knowledge that your position at the Department of Labor had been terminated.
Not at all, not only in December, throughout. This notion about termination, Chairperson, I hear it from this commission, to be honest. My understanding throughout has been precautionary suspension, and I have no evidence to the contrary. As I say, the clearest acid test was the payment. So December got my money, November got my money, and December got my money and all that. And the January one got paid late, but got paid. So there is no 1 month where I did not get a salary.
Mr. Mani, your evidence in relation to the letter that you've seen by former Minister Mdladlana, dated the 29th of October 2010, can you give us your evidence on that? Did you ever receive that letter?
No, I saw it for the first time, like I said in that thing, so whatever I've said in that response, I stick with it. I saw it from the commission.
Mr. Mani, did you employ the services of lawyers in your disciplinary process?
Yes.
Who were they?
I think Tembalanga and Advocate Vuyani Ngalwan.
Thank you. I'd like to then take you to a document. It is in NN5, and it commences at page 290. You'll see NN5 on your right.
Ms. Hofmeyer, I see that we are at half a minute to 4 o'clock. I'm quite happy to sit longer if that suits everybody.
Indeed.
Mr. Mani, would it be fine with you if we sit beyond 4 o'clock?
No, I'm easy.
You have no problem?
I'm easy.
Okay. So let's continue and see how far we can go. Okay.
Thank you, Chair. Mr. Mani, at page 290 appears to be a letter that comprises 4 pages to 293, and appears to be a letter bearing your signature, dated the 15th of November 2010, written to Mr. Beloy. Do you recall this letter?
Yeah, I don't recall this letter, but I can see my signature. This
So
is why, Chair, it's important to get documents beforehand, so that surprises like these are not sprung up on a person.
Yes.
You confirm that it's your signature at page 293.
Well, he might need to read it to refresh his memory.
Indeed.
We can do one of two things. I don't know whether we would finish anyway with his evidence today, but if we wouldn't finish and it's within his plan to be available tomorrow, he could get a chance overnight to reflect on it, and we take it from there. Mr. Manye, how is your situation in terms of if we don't finish today?
No, that's fine, Chair. I can come tomorrow
You
morning.
could come back. Okay, no, that's fine. If you need more time to look at this letter before you give an answer, we could skip it for now, and then later on or tomorrow morning you could deal with it. But if you are able to deal with it, that would be fine.
Yeah, Chair, I need to read it, Chair.
You need to read it.
So I think tomorrow will be fine to respond to it.
Yes. Okay. Ms. Hofmeyer, is that fine with you?
Yes, certainly, Chair.
Yes. Okay.
Then let us move, if we may, to a further aspect in relation to the charges that you understood to be allegations at the time. When you responded to the Commission's questions about charges, your response is contained at page 38 of NN2. Can you please call that up in front of you?
I'm sorry, what page did you say?
Apologies, Chair. It's NN2 and it's page 38, 38.
Okay, thank you. Is there no aircon in this venue?
I'm sure we'll be assisted.
There must be an aircon. I think somebody will attend to it. Okay, thank you. You said 38.
3A, Chair.
Thank you.
And just to give you the benefit of the questions that the Commission asked, to which your paragraph 7.2 is an answer. Chair, just for the record, this appears at page 120. I don't suggest that you and Mr. Manye need to go there. But at NN2, page 121, is the question 7.2 to which you're responding. The question was, what were the charges against you? And Mr. Manye, please can you indicate the answer that you give?
On 7.2,
Correct.
yeah, I said it's a litany of frivolous, trumped-up operational issues. It is available at the state attorney.
So you indicated the state attorney might be able to assist in relation to those charges. The Commission has further investigated, as we do in relation to all information that we obtain from witnesses and persons interviewed. And so what I'd like to take you to, if I may, is a document in NN5. I want to start prior to the document relating specifically to the charges, to a document that you'll find at page 2 of Exhibit NN5, Chair.
I'm sorry, Ms. Hofmeyer. NN5. Okay. I've got it now. What page?
Page 2.
Thank you.
This is a letter on its face between the Royal Norwegian Embassy and Ambassador Makubela. Do you see that?
Yes.
Please indicate the date of the letter for the record.
12 March 2010.
Is this a letter that you've seen before, Mr. Manyi?
Yes, I think I've seen this letter.
Thank you. The letter indicates in the first paragraph that Christian Hildan of the Norwegian Embassy is writing to Ambassador Makubela. He writes in the first paragraph, I feel that I should write to you as head of protocol in South Africa and thereby responsible for relations with embassies on a matter that is sensitive. This issue is contrary to Norwegian ethic and our cooperation with South Africa. Mr. Manyi, you indicated that you had seen this letter before. What is the sensitive issue that is raised in this letter?
Yeah, Chair, if I just go on memory. At one point I was sitting in my office, the Department of Labor, and then I get a call from Vic van Vieren, who worked a lot within the Busa space, Business Unity South Africa. At that time, Vic was working for ILO. So Vic calls me and he says, do me a favor, man, there is this ambassador that is here. Can you accommodate him? He wants to talk to network people, the network partners, were one of them, about decent work. So can you accommodate him? Then obviously I said, okay, no problem, he can come. So then this Norwegian ambassador then comes. Then I go and attend to him. And then we have a discussion about decent work and all of that. And then he then raises an issue. He says Norwegian companies have got a problem with BEE. So then I said to him, oh, okay, I can assist with that, with BEE. It's a subject I understand very well, as it were. And at the back of that, Chair, there was in the country, still there, I think even today, something called BEE Advisory Council, which advises the President. Now, the Minister of Labor was a member of this council. As the DG, I was his alternate in this council. So, from where I'm sitting, even while I was a DG of Labor, but because of that BEE Advisory Council, I saw it as part of my responsibility as well, and also being a South African, to be involved in BEE. And if I can help anybody to understand BEE, I would do that. And it turns out at the end of it all that this ambassador took the wrong end of that offer to assist him, and he tried to conjure it as some kind of commercial activity of sorts that I was trying to solicit from him and so on. And then there were all these letters written to a whole range of people. I think even the Minister Mdaldana was involved, even the public protector was involved, and I think there was an investigation, by the way, into this matter. And this ambassador was then asked to provide more information. And I think this concluded through the public protector not able to go any further because there was no more information. There couldn't have been any more information, Chair, because it was a meeting that it's something that had started and finished in a meeting, and there were good intentions on my part to assist these companies. It's something I don't apologize for even today, that if anybody was to come, I would do that. And even in hindsight, if one has to say, in hindsight, should we have made that offer? It's a definite yes, I would have done that even today. So I've got nothing to look back and be ashamed of. And I keep saying to people, if anyone can say to me, I've been to any Norwegian company, that company stand up I've never been to any Norwegian company, so there was no shenanigan involved, although that was the take of the ambassador. So the ambassador was totally wrong in her summary of what he thought was happening. And indeed, if there was any semblance of truth in his contention, he should have come back with a bit more evidence, but he failed to do that. Even today, I challenge whoever to bring more evidence to try and revive that story. They're not going to come up with anything because there's nothing.
Thank you, Mr. Mani, for that explanation. You described, let me just ask first, did this issue form part of the charges that you faced in the disciplinary process?
I think so.
You described those charges as frivolous operational issues. Why was this a frivolous operational issue?
It's a frivolous operational issue, Chair, because if you have, there is no substance to this. It is somebody whose English is not even up to scratch, somebody that might have misunderstood the whole thing and all that. So to be charged for trying to be a good citizen of the country is frivolous. It's actually malicious. Maybe frivolous is a soft term. It's a malicious charge for a DG that is trying to help an outsider in the country to say, this is how I can assist you understand the laws of this country. And then somebody charges you for that. That's quite malicious. I hold that contention even today.
You focused on the aspect of frivolous. Why is it an operational issue?
It's an operational issue. It's a day-to-day things that happen. The operational issue for me are day-to-day things. It's not like part of the strategy was to do, it's not a strategic issue, it's just a day-to-day things that happen in the run of the mill. When you operate as a DG, you get approached by different people. So it was in a day's work. That's what's operational about it for me.
The letter from the Norwegian ambassador alleges that, you'll find this at page 3, Chair and Mr. Mani, that, and this is at the second paragraph of the page, they've introduced the meeting that they had with you and the fact that the topic would be the decent work agenda. And then they record in the letter, it was therefore totally unexpected that Mr. Mani used this meeting to further interests that are not those of his department or applicable to the decent work agenda. He did this by offering his own expertise on BEE as a consultant service to Norwegian businesses. We felt that he was furthering interests that were not related to his position as Director General. For this reason, it is now unclear how our future relations should be handled, because we do see cooperation with the Department of Labour as imperative. That doesn't read to me as a description of an operational issue, Mr. Mani. Do you accept that from the point of view of the Norwegian embassy, it was not an operational issue?
Chair, this is just an operational issue. And by the way, I think if you read what, if you take what has just been read out, for somebody, when you're offering to help, to then turn you around and make you a consultant, and all of that, and want you to, it's actually absurd, the chairperson, actually it's quite absurd that here you are trying to help and somebody says you're a consultant, and I mean, did I even give an invoice? Did I even say this how much is going to cost you for me to do this? Why is he making this a consultancy issue? I didn't even talk money with this ambassador. This is totally preposterous for them to make this kind of conclusion.
Well, maybe what you should do, Mr. Mani, is to try and capture what the ambassador said the problem was, or what assistance, if any, he was asking you to provide, whether yourself or government or the Department of Labour, what he actually wanted, and what your response was in terms of what is the offer. I think you made a reference to offer. What was the offer in concrete terms that you told him so that we can understand what the exchange between the two of you was? I know it's been a number of years, but you do your best.
It's quite an alive issue. This media reminds me about this all the time.
Yes.
So I'm quite alive to the issues. You see, Chair, this is why I was also explaining the broad-based council thing, because this ambassador didn't even understand that, although I was a DG of Labor, I was an alternate to a BE advisory council by virtue of being a DG. At that time, there was no deputy minister at the Department of Labor. So therefore, from where I sit, it was within my brief. By the way, even if, Chairperson, even if it was not within my brief, there was absolutely nothing wrong with me as a person saying, I'm going to assist you. If I had said to him, this is what it's going to cost you, then you are talking. This is a kind of thing, by the way, during those times, Chairperson, I was actually on my prime on these issues of transformation. I was doing these talks freely. If one can Google my profile around those times, this was my space. It was either employment equity, I would give talks. If it was BE, I would be giving talks. So if you have a company here that doesn't understand this thing, I've participated in the development of some of these codes. I've participated in these amendments of the BE Act. It's something I understand extremely well. So here am I offering a service to this person, and somehow he conjures that up to something negative. I think it's quite a shame.
But just go back to articulating what he said his problem was, or what the problem of Norwegian companies was, and what was he asking you to do about it?
No.
If he was asking you to do anything about it.
Okay, he was saying the problem of the Norwegian people of the Norwegian companies is broad-based BEE. That's how he.
So he was saying they have a problem with BEE.
Yes, they have a problem with BEE, apparently implementing BEE.
Or did he need an explanation of how it works and so on, or as you understood or they did understand what it means, but they were opposed to it, the Norwegian companies, as you understood what he said to you?
My understanding, Chairperson, of most companies that are international that come to the country, they don't even understand some of these concepts that are within BEE. At the time, BEE had 7 elements as to what is it that the company needed to do so that when it gets rated, it can get a proper score. What are the things that it needed to do? So that is called implementation of BEE. So what I would have done, for instance, is to have gone to them, to explain to them that in your procurement, make sure that when you procure, you also procure from black people. Make sure that you've got an enterprise development program. Make sure that, all of those things, all of those elements that are there, and so on. So that's what I would have explained to them, to say this is how this thing works. It's meant to ensure that there is more inclusion of black people into the economy, which was not actually too distant from what are the objectives of decent work, as it were. So it was not even too distant from it. So I still don't understand why he had an issue with my input.
Thank you. And your offer, was it an offer to explain to these companies what BEE means, what its elements are, and how it should be implemented?
Correct, Chair. Remember, Chair, at the time I was a full-time employee of government. Even if I had interest of doing a consulting anything on the side, I would have had to declare that, I would have to get permission for that. There's a whole process around that. And I have not been found to be doing private business during that time. So it's not something that I would have done. But given a chance, I would have gone to those companies to educate them about how this thing works. And as I say, Chair, even today, I make no apologies about that.
Thank you, Mr. Mayor.
Mr. Manyi, thank you for your explanation of what you understood to be said to you in that meeting and what you were offering in the course of that meeting. I would like to focus on what is reflected in this letter as being the Norwegian representatives' understanding, because they seem to have taken this issue very seriously. Do you agree with that?
I note that.
They understood the conduct in that meeting to be an offer from you to utilize your own expertise on a consultant basis, but to further your own interests and not those related to your position as Director General. Do you accept that that was their understanding of what happened?
I accept that that was their incorrect understanding.
You indicate that this was a frivolous matter. That was the answer you gave to the question about this being one of the charges.
Sorry, some echo of sorts. Can you repeat that?
Apologies. You described this as a frivolous issue, is that correct?
Yes, correct.
Are you aware how this issue was perceived by other arms of government and whether they saw it as frivolous or serious?
Look, I think by definition, other government people that are seeing it from a distance, purely because of who raises it, they might see it as a serious issue, a diplomatic issue and all of that. So for them, it might be serious. But for me, who's directly involved, you can see the frivolity in it and so on. So the fact that from other people that are looking outside in, they see it as something else versus a person that was directly facing this thing, we've got two different perspectives.
Thank you. The fact that others took it as serious is certainly borne out by the next letter in Exhibit NN5. You'll find that at page 4. That is a letter between the chairperson of the Public Service Commission of South Africa and Minister Mdladlana, dated 28th of May 2010. Is this a letter you've seen before?
I can't recall it.
Certainly, and please feel free to indicate if you'd like any further time to consider it. But I understand your answer to be you don't recall it. I would just like to pick up at the second or the third paragraph of the letter there in relation to the characterization of this issue as frivolous or serious. The chairperson there on the face of this letter writes to Minister Mdladlana and says, given the seriousness of the allegations made by the Norwegian embassy, the PSC is of the view that you should elicit statements from the parties in attendance at the meeting between the Norwegian embassy and Mr. Manyi, whereafter Mr. Manyi should be given an opportunity to respond in writing to the allegations, in brackets, application of the Aldi Alterum Partem rule. Mr. Manyi, just to be clear on your earlier testimony, you did indicate that this particular allegation formed one of the charges that you faced in the disciplinary process. Is that correct?
Yes, one of the allegations, yes.
And that process was never completed?
No.
So there was no finding one way or another in relation to this allegation?
Well, I think there was this particular one. I think it went to the public protector's realm. That's where it was dealt with. So then the public protector, I think it's actually all in the media as to, if one Googles this, will find that on the final analysis, the public protector was not given all the evidence that she required to make a finding. So that's my understanding of where it got left.
Mr. Manyi, the public protector's report in relation to the complaint against you was dated September of 2011. Are you aware of that?
I know about that one, yeah, but it was on something else, wasn't it?
That one related to complaints of Advocate Hoffman. They included an alleged conflict of interest between, given your position at BMF and your appointment as DG of Labour, but within that there is at least a reference to the complaint of the Norwegian embassy. Is that the one you were referring to?
Yes, that's correct, Chair.
Okay, when you go away this evening, that full report has been included in NN5, so you can refresh your memory about it. Don't think it's disputed that that report was issued in September of 2011. So I just want to get us clear in time. That's after you've moved to GCIS, is that correct?
Yeah, that's correct, yes.
And the disciplinary process didn't resolve this allegation for or against you, correct?
Can you just repeat that? There's an echo.
Apologies. The disciplinary process that you were engaged in while you were at the Department of Labour did not make a finding for or against you in relation to this allegation.
Not on anything. It was even the whole, in fact,
On any of the charges?
on any of the charges. There was no finding on it. There was no, in fact, on that letter, on that probation letter, which everybody seems to think is a termination letter, and we can deal with that when we get to it. Former Minister Mdladla also makes reference to the fact that there are allegations. They have not been, there's a wording that she is using. If I can just, well, if you go to that letter, I don't know where is it on your files, the second page, paragraph 4, somewhere in the middle. He says, although no decision has been made in regard to these charges, it is clear from your response that they are not unfounded charges, but then he concludes, there remain allegations of a serious nature. So that's the thing, you see, even he is interchangeably using charges and allegations. This is really where I am.
So as at the date of the 2nd of February 2011, when you moved into the position of DG of GCIS, this issue of the allegation of the Norwegian ambassador had not been resolved?
I don't remember the dates, but and the times and stuff, but I just know that at one point there was some pronouncement about that sort of concludes the matter on the basis that there is no further evidence that was given to the public protector. As to when that happened, I'm not so sure now.
Well, the Public Protector's report, you can find it in the same bundle NN5 at page 111.
Okay. I'll read it tonight.
Is dated the 27th of September 2011, correct?
Okay.
So that is a number of months after you'd moved into GCIS, correct?
Yeah, that's correct.
Thank you.
On those findings, because I'm just seeing this only now, I don't see anything that makes a finding on the Norwegian. Do you see it?
No, I haven't seen it, so I was going to ask for your assistance on that, because your reference to this being a matter dealt with and disposed of by the Public Protector, on my reading of this report, there's a reference to the fact of the allegation, but I have not seen actual findings on it, so maybe you can assist us in that regard. It may be that there was another report of which we're not aware. You did make reference to this Public Protector report at your meeting with the Commission on the 21st of October, and so efforts were made to seek to establish which report had been produced by the Public Protector, but it could be that we missed a report, so we would be interested in your assistance on that.
That finding that is at 8.1.1 that refers to a conflict of interest, but it says between his personal interest in the BMF?
Yes, Chair.
Is that something different?
It's different.
Oh, okay.
You see, that's my challenge with this report, and I really will ask for Mr. Mani's assistance of it. I have found one reference to the fact that the allegation was made. That comes from Minister Mdladlana's response to the Public Protector as she was investigating this complaint. I have struggled to find any other finding in relation to that particular issue. The focus of the report then becomes the alleged conflict of interest between your position at BMF and your role as DG.
Yeah.
It is possible that I've missed it. It is also possible that there is another report. So we're just going to ask Mr. Mani to assist us on that.
No, Chair, I think the Public Protector couldn't process this any further. I think she makes findings on things that have been properly investigated. And then she says, with the investigation and everything, this is the finding. But if she calls for evidence for her to do the investigation and nothing comes up, we're cutting her hands. I don't think she was able to take it any further. That's why I don't find it.
No,
I
that's
think what you could do overnight, and obviously Ms. Hofmeyer, to the extent that she might need more time, will do the same, is just to look at the report to see whether, in terms of issues that the Public Protector would say somewhere at the beginning of the report, are the issues that she is dealing with, whether there is a reference to that particular issue, and if there is, whether she says anything further, because normally you would expect that if a complaint is referred to the Public Protector or any particular body for investigation and that body makes findings, you would expect that if it has been unable to find evidence to justify a finding one way or another, that it would say so expressly, to say, this complaint was referred to us, we have looked into it, we asked for evidence, this is the finding, whether this way or that way, rather than leave it hanging. So it's necessary to check whether this is a report that relates to, among others, that issue or not. And if it is, whether she made a finding in regard to that, because also if she says that was one of the issues she was investigating but doesn't make findings on it, that might be something else as well. But it's important to look at it properly. Okay.
Chair, you see, this is another, from where I sit, if it was as strategic as Ms. Hoffman purports it to be, surely it would have, because it was in the realm of things that Advocate Hoffman, the other one, that was complaining about my conflict of interest.
The only one.
Yeah.
This one is Hofmeyer.
Oh, this is Hofmeyer. Sorry,
Hofmeyer,
I always call her
yes.
Hoffman. Sorry,
Yes.
apologies. Apologies.
Yes.
Yes. Advocate Hoffman. It was in that realm of things that he was raising and all that. So, but it's fine. Let's see if there's any way it's mentioned, but I'm almost sure
Okay.
it's a non-issue.
Well, thanks. Ms. Hofmeyer, since Mr. Mani is prepared to come back tomorrow, I wonder whether there is much purpose that would be served in continuing until 5 o'clock, or whether we should stop so that he can get a chance to look at all the documents that he might need to, and then everything could be quicker tomorrow morning when he has had a chance to look at everything.
Chair, I was going to move to another topic at this point anyway, so it seems convenient to adjourn,
Yes.
to give Mr. Mani that opportunity, and then
Yes.
what time would you like us to commence tomorrow?
What is your assessment of how much time you might need with Mr. Mani tomorrow? And how much time you might need with Ms. Oliphant
Chair,
afterwards?
I'm fairly optimistic we would finish both of them in the ordinary period of the day between 10 and 4. There are quite a number of issues to traverse with Mr. Mani. It's gone slower this afternoon, but that was because we took quite a while initially to resolve issues.
Yes.
So as I stand at the moment, I think I'm optimistic that we'll finish both witnesses without an early start.
Yes,
But having said that, would it be appropriate if we do need a bit beyond 4 to sit later rather tomorrow than start early?
From my side, that should be fine. I can't remember that there is something after the hearing, a meeting that I have or anything like that. So that would be fine from my side. But will Miss Oliphant be in a position to go beyond 4 o'clock? Will she be needing
We
to
can
take
check
a
with her.
flight? Take a flight to go back?
My understanding of the Secretariat is they try to schedule the flights at least the day after because of the risk that there's a follow-over, but
Yes.
I don't have accurate
Yes.
information on that. We can make inquiries.
Yes. No, that's fine. Then maybe what we should do is adjourn and start normal time at 10 tomorrow.
Certainly.
But I take it that with Mr. Manyi, you probably wouldn't need more than 2 hours.
I would expect so, Chair, particularly if we move faster,
Yes,
given the
yes,
time that Mr. Manyi will have overnight, something
Yeah.
of that order.
Yeah. Okay, Mr. Manyi?
No,
I don't know if you want to say anything.
No, Chair, that will be fine because I've got a flight back to catch in the afternoon tomorrow.
Tomorrow, okay.
Yes.
Okay, no, that's fine. Thank you very much for your cooperation, Mr. Manyi. We are going to adjourn now, and then tomorrow we'll resume at 10 o'clock in the morning. We adjourn.